Insolvency and Bankruptcy Code 2016 was a disruptive, game-changing enactment, basically introduced for the purpose of improving the mechanism to remove stress from stressed assets. It was brought from 1st December 2016, and at ASSOCHAM, we thought it fit to revisit this in the long journey of 7 years, minus of course the 1 year of COVID. What are the various milestones, what are the various impact of the legislation is what we are thinking about discussing today. There have been several beautiful thought process emerging in this, several dimensions have come. Justice M.M.Sundresh, sitting judge of the Supreme Court, came here and addressed his the nuances of this legislation. We had the Executive Director of Insolvency and Bankruptcy Board of India. We have panel discussions, 3 technical sessions with leading experts across the country going to deliberate on the achievements, on the milestones, on the way forward, on the obstacles, on the constraints and deficiencies overall with respect to the regulators, with respect to the adjudicating authority, with respect to the judiciary, with respect to the various stakeholders, prominently or most importantly the debtors and creditors. All these aspects, a 360-degree view on several dimensions, are going to be discussed today and deliberated in this conclave. Yeah, I am the chair of South Regional Council of ASSOCHAM for the Corporate Law Council, and I am also the practicing company secretary in corporate law field as a litigation representative for NCLT and NCLAT, managing partner of KSR & Co. Company Secretaries LLP, Bangalore, Chennai and Coimbatore. Thank you.
Mr. Garg, representing the regulatory body, a very good morning to all of you. 2 things happened in the morning. There was a slight delay in my flight. Secondly, when we are about to light the lamp, we are not able to do it because lighter was missing. The lesson to be learned on both occasions is that for the success of any system, there has to be a coordinated effort. Now, we have today amidst us entrepreneurs, bankers, regulator, lawyer and a judge. So my congratulations to the organizers for having thought about this meeting by calling different stakeholders. Now, much has been said by all my predecessors. I would like to collate and make my presentation. What is the need for this code? As the father of the nation has aptly put it, an entrepreneur holds his property for the betterment of others. Conceptually, we have to think about it. World has become a global village. Therefore, as we expect from the entrepreneur, every other individual and stakeholders, be it the government, be it the court, be it a public person or an individual, to make sure that a company or industry is running smoothly. This is in the interest of everybody. This change in the thinking process is the result of this code. There's a beautiful poem in Sangam literature. A king was asking the poet, what's the difference between myself and a common man? Then he took him to a forest and showed a hunter, a poor hunter, waiting for days to catch his prey. And then after catching it, he is happily moving. King did not realize the message, and the poet told him, look, you are an individual at the end of the day, so is he. There are three factors like happiness, sorrow, and the needs. Everything's common. Natural elements are common. Therefore, what is required to be done by a person who have is to use the resources for not only for himself but for others. As Mr. Gagas succinctly put it, what we had earlier was an act of 1920, a Provincial Insolvency Act, which was of vintage origin. Amendments went through. Therefore, from the 80s, realization came that we need to move on and think differently to make this nation as an industrialist nation. Therefore, various committees have been set up, starting from Tiwari's committees, ending with Viswanathan committee. As he, again, as stated, prefaced it, you have SICA Act, then recovery of dues due to banks and industries, institutions, Financial Institutions Act, 1993, Surface Act, amendment to Companies Act. But in all these enactments, we would only see one objective behind it, that is to recover the dues. For the first time, a recognition has come into being that not only the lender, but the borrower also will have to be given due credit. The primary effort is to recover and revive a company. And in the event of its inability to get revived, to go for liquidation. Code introduced in 2006 is a work in progress. Mr. Mukherjee was saying something, Mr. Parasuraman was again highlighting something, and so also Mr. Ravichandran. There are certain issues with respect to role being played by a financial creditor, issues with respect to an insolvency professional, resolution professional, issues from a debtor, a corporate debtor, performance of the court. Broadly put in, all these grievances are true. For the first time, we have created a code addressing the grievance of all the stakeholders. Therefore, it takes time. The problem lies with the speed with which it is required to move on, the understanding of the code by the different stakeholders. I do not wish to go into the legalities, as the provisions are being upheld from time to time, starting from sub ribbon and ending with Dilip's case. Supreme Court on its own understands the mechanism, and therefore, whenever it is required, it gives a healing touch. Now, from the point of view of a financial creditor who forms the committee of creditors, probably a different thinking has to come to prioritize revival of company rather than going for liquidation. The second aspect is on the role required to be played by the resolution professional. A lot of things are to be said on this. An element of expertise is very often missing, and which can be attributed to the committee of creditors also. A resolution professional has a limited role to play. He has to act as per the dictate of the committee of creditors. The code gives more flexibility to the committee of creditors. Absolutely. Therefore, what we are seeing is that the resolution professional at times exceeds his brief. This is an area of concern. Apart from lacking the requisite expertise, he takes a role which is not expected to do, and indulge in activities not to the betterment of the company, which is already in sufferance. Having said that, what can one say about the role of the adjudicating authority? Here again, part 2, if you could see, starting from section 30. An adjudicating authority is not a judge in that sense. His powers are defined and restricted under the code. What is he supposed to do? Which, as a judge of the Supreme Court, I'm just seeing very often that it is in the mindset of the presiding officer who is acting as an adjudicating authority, along with the others, is to take the role of a decision maker. This is something which is not supposed to do under the code. Now, an adjudicating authority has to see as to whether the procedural compliance is in place. In other words, his role is constrained and restricted under the code, so that his brief is to seek the due compliance, which is enshrined in the provisions, and therefore the objective. And third factor is the time limit. Now, we have broadened the scope, especially the definition clause. As a result, litigations are mounting. If we actually give the interpretation as sought to be intended by the legislature, we'll be requiring at least 5 to 6 times of the infrastructure which we have now. That is absolutely required, being a necessity. If we go by the time limit given to every other stakeholder under the code. Now we have, under part 3, we have opened it little bit more further by not only reducing the financial, the monetary limit, but giving to a forum, which again is going to be a huge issue. something has been said about the amendments being made. This code is in work in progress. There are multiple reasons. For the first time, an attempt is being made. We have adopted the ancestral model law. When we adopt a principle or a law being enacted based upon a different methodology, it does give a lot of practical difficulties. That is the reason why we are having amendment after amendments, be it by a legislation or by way of an ordinance. We have to be patient. The code is actually working. In a system like ours, where we lack coordination, where we have numerous cases pending, despite prioritizing these sort of cases, delay is bound to happen. There are certain areas, which, in my view, which might require certain consideration. Again, as it has been said, we need to have a larger group of resolution professionals. I agree with Mr. Garg that from individual resolution professionals, we need to move on to institutionalized resolution professionals. The reason being, you can actually train them, pick them as per the needs of a particular company. As a legally trained mind, even I may not be able to deal with the certain nuances involved. Therefore, institutionalized professionals are very much required. Coming to the adjudicating authority, I think here also we need to have an out-of-box thinking. There has to be a trained set of minds instead of a purely legally trained minds. A lot of grievances with respect to waterfall mechanism, though it has been upheld by the court. I find there are good messages under section 53 by pushing the crown debt, as we call debts due to the governmental agencies, much lower. But on a personal note, I still feel that it should be pushed to the bottom, not only against both secured financial creditor and unsecured financial creditor, but as against operational creditors also. That might be the need of the hour. One more issue has been flagged off by them. That is with respect to cross-border insolvency. I believe what we have under the code is grossly inadequate. Courts are trying to innovate, like in JDR case, JDR's case. We need to, the world has become one, a global village. Cross-border insolvency is a subject which required adequate legislation. Similarly, I feel the concept of mediation has to be given more impetus by having specific provisions, notwithstanding 12A and its interpretation. We have to evolve a system by which industries not only survive, but continue to be a going concern and flourish. Thank you very much for giving me this opportunity to express my thoughts.
I take the pleasure first to extend our gratitude for accepting our invitation and giving his valuable time and traveling from Delhi to here. Sir, once again I would like to thank on behalf of SHM, the Honorable Justice, Mr. M.M.Sundresh, sir. So let's have a round of applause, please. So,
as the chairman of SHM Southern Development Council and Karnataka State Development Council, I am very happy that today's conference and conclave on IBC is very, very important as India is growing towards a knowledge power, a macroeconomic power, and many industries are coming to India. This is very significant. Especially the manufacturing GDP of the country is growing from 17% of the total GDP to 30% or more in the next decade. This IBC is a very, very important issue, and 2016 IBC code in the country has been a breakthrough. But a lot more to be done going forward on simplification of the process, scaling up the capacity, speeding up the process, skill building in the whole system and make it more robust, and strengthening the basic foundation of strong professionals will drive this to the next level. I'm sure this conference has come at the right time, and we are very, very honored today to have Honorable Justice of the Supreme Court of India, Shri Sundaresan, to grace this occasion. And we are going to have a lot of deliberations on 6 important technical subjects based on the regulator, the stakeholders in the form of debtors, creditors, and the professionals, and also the legal experts. So I'm sure a lot of takeaways from this conference for all of us. Thank you so much.